Hello, today we're going to start the lesson on Chapter 4, Criminal Law. And before we can really discuss the law, we really need to discuss the specific kind of how our government is set up. We have three separate but co-equal branches of government. We have the executive branch, the judicial branch, and the legislative branch. And each of those branches of government has checks and balances power on the others. And it's meant to try to um, make it the least likely as possible that you know one of those branches is going to become tyrannical and um, be a problem. So law enforcement officers fall under the executive branch, right? We are enforcing the law. That is our job. The legislative branch is to write the laws, right? We talked about there having to be a written statute for the law. That's the responsibility of Congress. That's the responsibility of the legislative branch. And then the judicial branch, their job is to operate the court systems to hold people accountable for violating those laws. But then they also have an added responsibility, and that is they are basically the protectors of the Constitution. So the Constitution is the supreme law of the land. It is above laws passed by the legislature, and it limits the powers of the legislature by stating specific, like the Bill of Rights, things that they cannot do, right? They cannot do certain things. Now, there are obviously always going to be exceptions, like we don't have limitless free speech in this country, right? We have reasonable limits, and it's up to the courts to basically decide what those are. When they issue decisions in appeals court cases and such, we call that precedent. We call that case law. And that means that from that point forward, that's how all the lower courts are going to decide. So if the Supreme Court says, for example, these are the outer limits of this exception to the search warrant requirement, then from that point forward, every court in the land is going to follow that precedent. So let me share the screen here and we'll start kind of blowing through the PowerPoint. Understand that I don't really teach the way that this is presented in the PowerPoint. And so there's some of this stuff I won't talk about here. I'll probably talk about other places. But the written law is passed by the legislature. That is the penal code, the Missouri revised statutes is what we call it here in Missouri. But if you're from other states, then you're going to have some version of that in your state, and that's going to be your state laws. You're going to have local ordinance, city ordinances that are going to be published. And then you have federal law also that is passed by the federal Congress. And then the case law is these decisions by the judges. Common law really is kind of a moot point anymore. That's an old British tradition where they would basically use case law to kind of, for lack of a better term, kind of come up with the elements of the offense. But we really don't use it anymore. So that being said, we also have civil courts, and that those are to help resolve disputes between individuals so that we don't have to take a right equals might approach and try to beat people up that we don't agree with or whatever. There's a legal way to do it. So for example, I teach at Missouri Valley College on a contract basis. So they have a contract. We have a contract, and it states that I will teach this and a couple other classes this semester, and they will pay me, assuming that I meet my obligations to teach the class. And so if I meet my obligations under the contract and then they default or decide they don't want to pay me, then I could sue them. And then it would go to court, and the court would, assuming the facts as I've stated them are true, then they would order the college to go through with their contract. Same way the other way around. If I don't teach my classes and then I try to sue them, to say you need to pay me, then they could prove that I didn't meet my obligations under the contract. So, you get into all kinds of manner of small claims kind of disputes like that. And it's the job of the civil courts to kind of help keep civil society moving forward. We have an outlet to resolve those disputes that doesn't come with threats or, other things. So that being said, administrative regulations, that is where and usually it comes from the legislative branch kind of ceding some of their power to a regulatory agency for the purposes of oversight of certain things. So we have, the Environmental Protection Agency at the federal level. We have, the Department of Health, the CDC, Center for Disease Controls, these things. They have certain powers and certain things they're allowed to do by law because they were given that authority under statute. And likewise, if you work in a number of professions, including law enforcement, you are probably regulated by the state. We have a post commission. It's called Peace Officer Standards and Training Commission. And they have authority to grant peace officer licenses, withhold peace officer licenses, discipline peace officer licenses, and you have to have a peace officer license to work as a police officer in the state of Missouri. So they have some power to flex there. It's not like if I don't do my continuing education credit this year, it's not against the law. Like I won't get charged with a crime or anything like that, but I will lose my license and therefore not be able to work in my profession anymore. Right. So, I mean, they have some power to flex. It just looks a little bit different. Banking, banks are regulated by the federal government and they have very strict rules that they have to follow. So all of that's examples of administrative law. We already talked about case law and precedent, the principle of stare decisis. We want things to remain as consistent as possible. So therefore, we look to prior similar cases and stuff. If you actually have the pleasure of reading a Supreme Court decision, they will reference ad nauseum prior cases that for different elements of their decision, to say, hey, we haven't decided a case precisely like this, but in this case, they gave this guidance or this rationale for the decision, and I think that applies here. So it's a big thing in criminal law, and they love these Latin terms. Stare decisis is a Latin term. When we get a little bit further in, we talk about the elements of the offense. Those are Latin terms. They'll be all over the place. There's all different manners of 3 different classifications of crime in statutory law. We have felonies, which are the most serious. They are punishable by a year or more in prison. All kinds of serious crimes are included in that. They list murder, rape, aggravated assault, robbery, burglary, and arson. But it also includes check fraud and controlled substances and different things like that. It's not all violent crime, right? It's anything that's serious enough to be prosecuted at the felony level. And really it really comes down to how long can you expect to be, or can you anticipate being punished for. So, and there is certain things that happen whenever you're convicted of a felony. You lose certain rights that you once had, depending on where you live, depending on whatever. You lose the right to bear arms, you lose the right to vote, and oftentimes you lose your freedom for a period of time. Misdemeanors, right? They are generally just going to be jail time, less than a year, and they include a lot of your smaller kind of petty crimes. Infractions are laws that are so not serious that they don't even come with jail time. We're talking about fines. Um, you know, so a lot of your city ordinance stuff would be considered infractions. You don't mow your grass, or you don't, or you jaywalk, or, littering, that kind of stuff. Um, Treason is a felony, just to be sure, but it's the only crime that's actually specifically outlined in the Constitution, right? And that is a United States citizen. And this is important. It has to be a citizen. Only a citizen can commit treason, because treason is actually a betrayal, right? And that's why it is specifically mentioned in the Constitution. It means that you're trying to overthrow the government. You're trying to wage war against the United States of America, and you're a citizen of this country, and you're trying to do that. And so it is the most serious crime that there is. Now, contrast that with espionage. Espionage is also a felony. It's also pretty much the same activity. It's somebody working against the interests of the United States, but they're not a US citizen themselves. They're a foreign actor that's coming in and infiltrating our country, trying to conduct spying activities, basically. So the same action, if it's committed by a foreign national, would be considered espionage. If it's committed by a United States citizen, it would be treason. So we have three elements, or three things that we want to talk about. Really, two elements. The third one is just saying that they have to exist at the same time. But we have to have an act, right? There has to be certain conduct that is, an act that has to be committed, or a failure to act. We'll talk about that in a minute. And that's the actus rea. That is a Latin term. It has the word act in it. So hopefully you should be able to remember actus rea means the criminal act. Mens rea is talking about the criminal intent. It's not the same thing as motive. Motive just means you have an arguable reason why you want to commit a crime or whatever. Mens rea is the purpose for which you committed the act, right? It's very specific to the crime and what your intent was at the time of the crime. And then concurrence just says that you committed the act because of the criminal intent. That both have to exist at the same time. So when we're talking about the actus rea, we're talking about a voluntary act or a failure to act. So like Missouri, there is a statutory requirement that you have your kids in school one way or another. You can either enroll them in the public schools, or you can be a homeschool parent. But there's certain criteria you have to meet. And if you fail to do that, you can be charged with that. Even though you didn't commit an act per se, you failed to commit an act you were obliged to do. So failure to act can sometimes be the thing. Usually, though, it is an actual overt act. So now we're going to talk about incomplete crimes, conspiracies, and threats. So if we talk about if you're going to commit, or if I'm committing a bank robbery, right, and I walk into the bank and I'm about to pull out my gun and I'm about to say, "Hey, everybody, get down on the ground," right? And there's an astute security guard that notices a bulge in my shirt, right? And right as I say, "Everybody down," he tackles me, right? I say, "Everybody down," and he tackles me to the ground. Have I committed bank robbery? It's a good question, because whether or not I can be charged, and they call that inchoate crime. I think somewhere, no. Where is it? I know it's there. Yeah, inchoate offense. That means I didn't fully carry out the crime. And it's going to be judged on whether or not I committed an overt act in furtherance of the crime. In other words, if if I get if I get stopped outside of the bank and they see that I'm carrying a firearm, right? That doesn't necessarily prove, absent further information like, testimony from other people or whatever, that doesn't necessarily prove that I was going to rob the bank, right? It just proves I'm armed outside of a bank. But because in the situation I expressed, I said everybody down, right? Then I get tackled. It's pretty clear I was intending to rob the bank. So because I began basically committing the crime, I don't have to completely go through with it in order to be charged. So a crime that's interrupted in progress, as long as there's enough evidence that that was my intent and that was the act I was trying to commit, I can be charged, even though it's an incomplete, inchoate offense. So the mens rea, the blameworthy state of mind, the criminal intent, however you want to call it, right? It's not motive. Motive is different. Motive becomes important at trial, because they're trying to speculate about the mens rea. But when we're talking about the mental state, the culpable mental state, there's basically four options: purposeful, knowing, reckless, and negligent. And so purposeful, thought I was in here, and I guess it's not. Okay, purposeful just means that you intended to commit the act and you intended the result that followed, right? It is the highest and best in terms of criminal intent. So, I purposefully, I shot him in the head because I meant for him to die, right? Knowing means that you voluntarily committed an act and you knew what the likely outcome was, so I shot him in the leg, right? Knowing that that was likely to cause serious physical injury or death, right? I didn't necessarily have, they don't have to, and this isn't about necessarily what the truth is. This is about what level of mens rea does the prosecutor have to prove. And so highest and best is the hardest to prove most often. So, because how do you prove that somebody intended? Well, some of it can be based on where did you shoot them, right? Some of it can be based on how many times did you shoot them. Some of it can be based on, what did you say? If you said, die, die, die while you're shooting them, then that makes it pretty easy. What were you telling other people before you did it? I'm going to kill them, and then you shoot them, right? So I mean, there's different ways to prove it, but purposeful is the worst, right? Knowing is, again, you might even say synonymous. It's pretty close, right? Purposeful and knowing are pretty close cousins, right? And but purposeful is easier to prove, right? Because it's very widely known, and any reasonable person would know that if you shoot somebody, there's a likelihood that they're going to die, right? There's a likelihood they're going to be seriously physically injured or dead. So purposeful and knowing kind of go together. Reckless and negligent are kind of the same way. The difference between recklessness and negligence is recklessness means that you act with conscious disregard for the safety of others, basically. So if I'm driving 125 miles an hour on the highway in heavy traffic, that's reckless, right? If I'm driving 70 miles an hour in a 65, it probably doesn't meet the bar for reckless driving, right? A lot of times it means it's just so far beyond that any reasonable person would regard it as reckless. Negligence has to do with, you don't necessarily have to prove their conscious disregard. You just have to prove that any reasonable and prudent person would regard their their behavior is reckless, and then you can get them under negligence. So reckless and negligence, you see that in, so purposeful and knowing, you see that in murder statutes. Recklessness and negligence, you see that in manslaughter charges. You see that, like a DWI where somebody dies, right? They're going to try to charge them with that death as a reckless, negligent act. Strict liability. Strict liability means there is no mens rea. That means you only have to prove the act happened. You see that in statutory rape. That is probably the most significant example, right? I don't have to prove purposeful, knowingly, recklessness, or negligence when it comes to that. I just have to prove that somebody had some degree of sexual contact with a person who's under a certain age and they're over a certain age. And we do have kind of carve outs in the statute for like high school relationships. And so there has to be a certain spread in the age. If you have somebody that's 18 and somebody that's 16, and we're not trying to go after that, but like we have somebody that's 35, 45, 55 years old or whatever, and they're dating a 15-year-old, that's a problem. Right? So strict liability means that you only have to prove the act, you don't have to prove intent. And concurrence is that idea that the mens rea has to motivate the actus rea. So what it means is that if I can prove that somebody caused the death of a human being, but I can't prove that they had that they did so knowingly or purposefully, then that means we might have to charge it as manslaughter if it's reckless or negligent. It means that I have to find, it doesn't mean the person gets away with murder, right? It just means that we have to find the statute that fits the crime. So concurrence means that one thing can't exist without the other. Except for, like, say, strict liability, you don't have to have the intent. But and it talks about first degree murder. First degree murder has an extra element, right? In almost every state, or I think every state, and that is this pre-planning element, the malice aforethought, the with prior planning of some sort has to take place, and you have to prove that, and that's hard to prove. And that's why it is so common for plea bargains to include a second degree murder charge on these kind of cases, because of the difficulties in proving the pre-planning element. There's ways to do it. You go by what were they telling other people or whatever, or like if it's something where it's a conspiracy, like, which I forgot to mention, conspiracies can be charged people that didn't actually participate in the crime, but they contributed in different ways. So the getaway driver at the bank robbery, right? He didn't go into the bank. He didn't say, get down. He didn't say, give me your money. He didn't point a gun at anybody. He's just out in the car, and he's going to help him get away. Well, that means he's part of the conspiracy to commit the act. He can be charged with bank robbery, even though he wasn't in the bank. So with murder, if we're trying to prove that pre-planning element, we can prove conversations that were had, or if I contract with somebody to commit the killing instead of doing it myself, then I'm part of the conspiracy, right? I'm a co-conspirator in this murder, even though I didn't do anything other than hire a guy and give him some money. But you have to prove an overt act in furtherance of the conspiracy in order to charge somebody. Having a conversation is not by itself a conspiracy. If I talk to somebody and say, hey, I'd really like to have so and so killed, that is not a crime yet, you know. But if I give them some money and make a plan and an overt act in furtherance of that conspiracy, then absolutely it can be charged. So that's kind of the important things here. It may seem obvious, this concept of corpus delicti, the body of the crime. You have to be able to show that a crime occurred. But believe it or not, it is actually more difficult than it might otherwise seem in some circumstances. So I'll give you an example is we get a missing person report and there's plenty of reason to suspect foul play, but yet we can't find their body. And we don't have any evidence that they were assaulted. We don't have any evidence that they, lost blood. They don't, they just disappeared from planet Earth. Well, we can't assume that they're dead just because it's the most reasonable explanation for their absence. Because in theory, technically, they could just be gone, you know? They could have just decided they don't want anybody to know where they are and they want to start fresh somewhere else and they're just going to skip town and never come back. And that's, remember, if we're going to try somebody for a crime, we have to prove that a crime took place. We have to prove it beyond a reasonable doubt, which we haven't really got to those things yet. I'll post a different video where we talk about that. But it's important that we get this right. We can't prove beyond a reasonable doubt that so and so killed so and so without proving that so and so actually died, without proving that this happened. Because otherwise, that's all they have to do for reasonable doubt is say, "How do you know they're dead?" See what I mean? So that being said, that's what we have. So that's all for this video. I will kind of post a separate video about the other stuff. Let's get it over with. Goodbye.